Ladies and gentlemen, welcome back to the Indie Zone. It is the evening of July 23rd, 2026, exactly 1 year ago today. Brian C. Kohberger was sentenced and convicted of the 5 very serious first-degree felonies that he was to have stood trial for in August of 2025. There are many conversations that have been going on in the community, particularly since defense expert Cy Ray appeared on the Custody Queens podcast last week and said words to the effect that he believed that the world had not seen the end of Mr. Kohberger, that there would be another bite at the apple, an appeal, and then he used the 3 magic words, miscarriage of justice. That is, of course, the legal standard announced by the United States Supreme Court June 18th in Hunter versus United States, standing for the proposition that if a party is able to show a miscarriage of justice, that there may be an opportunity for a higher court to look at what happened in the lower court, even where an appeal waiver was signed, as Mr. Hunter did and as Mr. Kohberger did. Now, in Mr. Kohberger's case, his option for relief would be under Idaho's Uniform Post-Conviction Procedure Act. There is a strict deadline, a statute of limitations, which is 1 year from the expiration of the time for appeal or 1 year from the determination of an appeal. Under Idaho law, it appears that Mr. Kohberger has exactly 42 days from today to file for post-conviction relief, which would be on or about September 3rd, 2025. That is when it appears that the window will close for Mr. Kohberger to file a civil petition for post-conviction relief. According to the statute, it would need to be filed in the jurisdiction where he was convicted and sentenced, and that is Ada County, Idaho. Even though a part of this case occurred, it actually started in Latah County, and it proceeded for a longer period of time than the Ada County proceedings did. The bottom line is that's where he was sentenced and convicted. Ada County, and that is what the statute says. We are continuing to monitor the docket in Ada County. It does not appear as of today there is any petition for post-conviction relief styled as Kohberger versus Idaho, seeking to possibly set aside his conviction and obtain a new trial. It would be, if he does, and there is no indication other than what we've heard from Cy Ray indirectly, that he will, but it will be up to him to produce sufficient evidence when he files that petition of exactly why the appellate waiver should be set aside and that the case should proceed to potentially a new trial. There are absolute dangers if he does that. Recall that the state of Idaho sought the DP. This was a capital case, and they agreed that the sentence would be the maximum under the statute, but not the DP. So, if he proceeds and is successful, there stands every possibility that the DP will be put back on the table again. All of this is down the line, 42 days between now and September 3rd, and only comes into play if he files for post-conviction relief. We will continue to keep you posted as further developments arise. Until next time, thank you for joining us here today.